Good afternoon, everyone, and welcome to this session this afternoon, which is very topical in how to deal with challenges in retail and commercial leasing. I'm Miriam Kent, and I'm the Program Manager here at the Brisbane Business Hub. We are delighted to have you on board this afternoon for this session, and we look forward to you joining future sessions with us through the Business in Brisbane website, What's On, to check out other programs coming up. But firstly, I'd like to introduce John. John is a partner with Gadens, and John will be leading the session for us this afternoon. So delighted to have you on board, John, and thank you very much for your support today. I'd also just like to say we have the pleasure of having Marie Adshed in the room, Queensland's let's get that words right. Small Business Commissioner for Queensland. So really fantastic to have you, Marie, with us as well, and Luke from your team. So without further ado, I'll hand over to John. Thank you.
Thanks very much, Miriam, and good afternoon, everyone. Thanks, Miriam, for organising today's session, and to the Brisbane Business Hub for having me along today. We're going to go on a bit of a journey in today's session. We will get to the COVID issues, which I'm sure everyone's very interested in hearing about. But I wanted to start off with some basic measures first up, and particularly look at some preventative measures, look at leasing generally, and then move on to the COVID issues. So in terms of the first slide here today, there is a bit of an overview of the journey we're going to go on. And you'll see that I have on that slide KISS. It's not because I'm a KISS fan, albeit I am, but that's not the reason I put it there. It's because of the KISS principle, which I aspire to, which is keep it simple, stupid. So I won't be quoting sections of legislation to you today. I won't be talking in an overly legalistic way. I want to try and keep it as simple as possible, and hopefully that will lead to a lot of questions. And we do have the ability for you to send in some questions through the live event Q&A section of the portal. So please feel free to send through those questions. I will try and address them as best I can throughout the session, but I will also revisit at the end and make sure that we've covered off any burning issues that are coming through. So moving into the presentation proper, in terms of due diligence, I raised this as a preventative issue because if you are taking preventative steps before you enter into a lease, that usually means that the issues that arise during the term of the lease are much more easily dealt with, or there may not be any issues at all things going well. Now, the reason why you might carry out due diligence, fancy way of saying having a look at things, is because parties, when things go wrong, may look to do all of these things: dodge, duck, dip, dive, and dodge again. You'll notice that I have some music and movie themes throughout the course of this presentation. So it's really important to carry out your due diligence, because when things go wrong, parties are much less likely to be motivated to talk about it. But if you look into things upfront and raise them upfront, and you can deal with them upfront, make an assessment of them, then that's a much better way to approach them. And now some things may only become apparent later on in time, but there are certainly things that you can look at early on to make sure that the deal that you're entering into is the appropriate deal to be doing. You know, I look at leasing like a marriage, and you certainly wouldn't just sign up to marry someone without first taking a period of time to understand who they are, what they're about, and potentially what they're bringing to the table. So it's really important to carry out due diligence so that you have that understanding of what you're getting yourself into. And that's not just in terms of the relationship that you might be forming with a landlord or a tenant, but also the property that you're looking at taking possession of. And there are a myriad of ways of looking into those things. So what is it? Some of you, or how do you do it? Some of you may recognise the picture on the screen. For those of you that are a bit younger than me, you probably won't. That's Mrs. Mangles from Neighbours. She was known as the neighbourhood sticky beak, and that's really how you do your due diligence. You really look at things and take a keen interest in what's going on around you. And so from a landlord perspective, if you're assessing a tenant, you're wanting to understand their financial capacity, you're wanting to understand their previous track record if they have one, and you're wanting to understand how they've structured themselves, and we'll look at that in a moment, so that you can ultimately get to whoever's behind the operation and make sure that they are someone of substance. You also want to assess the business that they want to carry on. If that business is an improper business, or it's a business that is illegal, or may not be what you think it is going to be, you need to understand that up front, because it's too late once you sign the lease potentially to then have to go through a breach process, for example. So properly understand the business that's proposed to be carried out and make sure that that aligns with your values for the asset. We sometimes, for example, have religious organisations that are landlords, and they can't have immoral businesses being carried out on their premises. That's a simple example of what I'm talking about there. From a tenant's perspective, likewise, you want to understand who your landlord is. You want to understand how well they're maintaining the premises, for example. You want to understand what financial capacity they have to make sure that the premises will be properly maintained. You want to understand potentially who else is in the building if it's a multi-tenanted building, so you know who your neighbours are going to be. You wouldn't buy a house, for example, in a neighbourhood that you're not happy with. And then you might also look at the property itself, carry out searches to make sure that there's no legal impediment to you carrying out your business there, that there's no potential orders for assumption where you might not, you may lose the premises in a period of time during the term of the lease. So, it is really important to have a really good look at who you're dealing with and the premises, and make sure that it will work for you during the term of your lease. As lawyers, we are asked to advise on leases all the time, whether for landlords and tenants. And Lexon, who are our insurers, actually produce checklists that we are expected to follow, that are designed to make sure that we are bringing to the attention of the parties all of these issues. Okay, so if your lawyer is asking you to look at these things, don't dismiss it as the lawyer just being overly dramatic about the situation. It is a significant investment of money for both parties. It is like a marriage, and you need to make sure that you're properly looking at things before you enter into it. Okay, I mentioned a moment ago understanding structures, and what I mean by that is parties will set themselves up in many different ways, and they will contract in many different ways. They can contract as a sole trader, so in their own name, and in that situation, that party is personally liable for whatever they're signing up for. Likewise, parties can get together and form a partnership, and in that scenario, the partners are what we call jointly and severally liable. What that means is a partner is not responsible for whatever share it has in the business. It's responsible 100% for whatever happens. So partnerships can be useful from tax and other business purposes, but they do have some legal issues that come from them. Joint ventures are very similar to partnerships, but joint ventures are normally venture specific rather than an ongoing business, so we don't often see them in a leasing context. Companies are what we very often see, and people usually or quite often confuse a company with a business. A business is the enterprise that you're carrying on. It's the selling of the food or the providing of services. A company is actually a legal structure that might own the business or operate the business. Companies are created by incorporation of the Corporations Act, and they essentially are like a third party in the room. So if a company signs up to a contract or a lease, it's the company that's liable, separate from the individuals and human beings behind it. So if you are a landlord, for example, and you have a tenant that has set themselves up as a company, unless you are really comfortable that that company is of substance, you may want to look at other forms of security that you need to get to make sure that you're essentially going to have someone performing the lease if the company can't. And we'll talk about security in a moment. Where you have a trust type situation, a trust is not a legal person per se. It's a structure through which you can better deal with income and other financial issues. The trust itself is not who enters into the contract. It needs a representative, and that's what we call a trustee. And the trustee can be an individual person, it can be a company, it can be a combination of all sorts of different things. You can have more than one trustee of a trust. Again, if the trustee is a company, then all the issues that I just mentioned in regards to a company arise as well. So again, careful thought needs to be given to that. And then we see a lot of the major landlords set up as managed funds. Some of them are listed, some of them are not. And in that scenario, you may see funny things like responsible entity and custodians. They're just fancy ways of referring to representatives of the managed fund, and it operates very similarly to a trust type scenario. I explain all of that to you because, again, if you're a tenant and you're signing a lease and the landlord's a company and it's $2 and something goes wrong, your claim is only against that landlord company, and yes, it owns the property potentially, so there may be some value there. But if you have any, as a tenant, if you have any concerns about the landlord and its financial wherewithal, then these structures could come back again to bite you. So again, part of that due diligence is understanding that profile and making an assessment. From a landlord perspective, landlords will quite often ask tenants to provide security. So some sort of assurance that backs up the performance of the lease. They could be a cash bond, it could be a bank guarantee, it could be personal guarantees, or it could be guarantees from another entity altogether. Landlords need to carefully assess the security they seek, and the more a tenant is not of substance, the more security that a landlord is likely to ask for. So if you are a new business setting yourself up as a $2 company, your landlord's probably going to ask you for a bank guarantee of around 6 months, maybe more. They're probably going to ask you for personal guarantees from the directors, and that's all because they want a degree of comfort that if the company doesn't perform under the lease, then they have backup. As a tenant, you should be prepared for that, and if you are not willing to provide those things, you need to have compelling reasons as to why you're not going to provide that level of security. And ultimately, it's all up for negotiation, okay? It's not always a take it or leave it type situation. So as a landlord and as a tenant, you need to think carefully about what the security profile is going to look like. In terms of leases themselves, leases have two characteristics. Number one, they're a contract, and number two, they can be an interest in land if they're registered, particularly if they're long-term leases. The reason why I point that out is on the contractual side of things, what you need to have is an offer, an acceptance, and you need to have certain terms, okay? The earlier that you can deal with all of the issues as part of the offer acceptance process, the better. What you don't want to happen is you agree terms, or you think you've agreed terms, the lease gets issued and there's all these additional items in there that a tenant wasn't expecting. So from a landlord's perspective, you should always adopt the no surprises approach because that always helps in getting deals done quicker. And from a tenant's perspective, if there are any issues or concerns that you have, make sure you're dealing with them upfront and early, not trying to do it as part of the lease negotiation process. Because from a negotiation point of view, and we'll look at this a bit more in terms of disputes as well, you want to try and address all the issues as directly and as quickly as possible, and not let things drag on and not surprise anyone with anything you may be raising. And you also don't want to be talking about issues that are irrelevant or may not be particularly important. Ultimately, contracts are about two parties coming together, and the contract is there to set out what each party is going to do, and then also allocate the risk of the deal between the parties. Now, that allocation may be by one party agreeing to take on the risk, or one party agreeing to insure against the risk. There's many different ways that you can deal with risk, but that's essentially what a lease does. Okay, it creates a relationship and allocates the risk. You'll often see some parties try and avoid signing a formal lease and sign what may be a termed license document. Don't be fooled by that. Sometimes licenses are leases because of what is actually being agreed, and even if you do call it a license, it's still a lease. If it waddles and quacks, it's a duck, even if you're calling it a chicken. So bear that in mind. Don't try and short circuit the documentation for the sake of time or cost if it's appropriate to be doing something more formal. I just want to briefly touch on the fact that in terms of regulation of leases, there isn't a lot of regulation of leases generally. There is some under the Property Law Act, but broadly speaking, what is within the lease is what is agreed, and that's what regulates the relationship. So it's really important to make sure that lease document does what you need it to do on both sides. However, the only exception to that are retail shop leases. I've got up on the screen at the moment a checklist that we put together that helps parties assess whether or not they have a retail shop lease. I'm happy to share that with Miriam, and Miriam will be able to issue that to all of you. If it is a retail shop lease, then it will be covered by the Retail Shop Leases Act, and there are similar acts around the country in the different jurisdictions. And you can see that I've got the hearing protection zone sign there. What I'm trying to signal there is the Retail Shop Leases Act is all about protection, particularly of tenants. It's about trying to regulate as best as is possible the relationship between landlords and tenants with a skewed view of ensuring that tenants are not taken advantage of. Landlords don't like hearing that, but that's the reality of what the intent of the legislation is. The history being that in the early to mid-90s, a lot of tenants were taken advantage of by landlords, and we've seen that lessen as the playing field has levelled up, and there's not been that desire by landlords to necessarily take advantage of the conditions that may be operating at the time. In terms of the Retail Shop Leases Act, it deals with a number of key issues. I've set them out there. The two main issues I want to talk about there are compensation and relocation and demolition. The Retail Shop Leases Act contains within it rights in favour of the tenant where they're entitled to compensation from landlords if the landlord has done something or there is something within the landlord's control that causes disturbance to the tenant's use and occupation of the premises, or some sort of other interference. So common issues are you're carrying out works, there's noise, there's dust, there's vibration, and particularly say in a food premises type situation, people don't want to sit there if there's jackhammering next door. Another example may be you move or place something in a common area which diverts traffic away from someone's shop front, or you close a walkway or a mall, again diverting traffic away from someone's shop front. The Retail Shop Leases Act will intervene and entitle the tenant to compensation. That doesn't happen as directly in a commercial lease scenario. So if you're in an office building or you're not a retail shop lease, you are entitled to quiet enjoyment, but you don't have that very specific right to compensation that arises under the Retail Shop Leases Act. So when you're negotiating a lease that is not a retail shop lease, both landlords and tenants need to be mindful of what that risk profile looks like. And if you're a landlord that is planning some works, you probably want to tell your tenant that. And if you're a tenant, you probably want to ask the landlord if they've got anything planned, and make sure you understand what that profile looks like. Relocation and demolition, and what we mean by that is a landlord may want to try and relocate the tenant from the premises they've signed up for to different premises within the same building or in another building they have next door, for example, during the term of the lease. And demolition is where the landlord says to a tenant, we are going to demolish this building. Demolish being widely defined. It's not the concept of knocking over. It could be substantial renovation, refurbishment, etc. And we need you out because we can't do those works without you being with you being in there. The landlord, if the lease provides for it, can ask the tenant to leave. The Retail Shop Leases Act sets out a fairly specific process for both of those situations, including time periods. It also provides for compensation payable to the tenant. In a non-retail shop context, there is no regulation of those issues. So again, if you have a non-retail shop lease and these two items are dealt with in the lease, then you want to make sure the lease fully provides for all of the issues, okay? And from a tenant perspective, that's to make sure that you're not unjustly deprived of your entitlement to the lease. And from a landlord perspective, ultimately, if you know what you're dealing with, you're not leaving anything to chance, that's always going to result in a better outcome. So bear that in mind when you're negotiating your leases. Indemnities and insurance, I very briefly want to talk about these two issues, mainly because they're the things that lawyers negotiate the most. And I'm sure people think that, like this fellow, we sit in bed at night dreaming about insurance and indemnities and read about them and through the night. It's not the case. Indemnities and insurance are the two main ways in which we allocate risk through the leases. An indemnity is basically one party assuring the other that they will cover the other party for any losses that are suffered. Indemnities are contractually based. There is no law dealing with how indemnities all work, certainly not in Australia. So whatever the indemnity provisions in the lease say is what will happen. More and more, though, we are seeing a balancing of the risk allocation under an indemnity. I think any landlord that at the moment that is trying to get a tenant to indemnify the landlord for anything is probably out of step with the market. Landlords should be seeking to be covered for anything that the tenant causes or someone that the tenant is responsible for has caused. And landlords should, I think, also be excluding anything that they're responsible for. So if the landlord has caused the issue directly, they can't really expect the tenant to indemnify them for that. So as long as the indemnity is balanced, that should go through relatively easily. If the indemnity is not balanced, there will always be a fight, and the lawyers will always be fighting about it. Both clients have no idea what the lawyers are fighting about, but the lawyers are having the fight. But they're having the fight for good reason, so bear that in mind. Insurance is a really simple and easy way to try and cover risk, particularly for property damage and personal injury. Landlords will want tenants to take out insurance to protect against the common type issues that arise, so slip and fall, property damage, those sorts of issues. The reason being that if something like that happens, the parties really don't want to be relying on the indemnity or fighting with each other about who's responsible. Normally, the insurers just work it out. And again, what that looks like will sometimes be subject to the fight between the party solicitors, but that fight's being had to make sure that everyone's properly protected. You, as a tenant, you shouldn't be afraid to take out insurance. We are seeing a number of tenants who had business interruption insurance being declined coverage because of COVID. I read with interest yesterday that Clayton Utz and a litigation funder are taking on an insurer over that. And I'm sure everyone with business interruption insurance will be watching that case very closely, because ultimately you take out insurance to have coverage against things like that. The issue seems to be around the fact that some insurers are saying that COVID is a quarantinable disease, therefore coverage shouldn't apply, and that's really what this is going to be about. So let's see where we get to with that. All right, improper conduct. So you'll see there that I've got a photo of a kitchen sink. The reason I've done that is we quite often see parties who allege that the other one is acting improperly throw the kitchen sink at it. They'll literally throw up every single issue that they can. And quite often it's because they want to try and put a lot of meat on the bone and want to try and perhaps get the other party to negotiate a more favourable position. That doesn't always work, and we'll talk about that a bit more in the context of the COVID stuff in a moment. But what we normally see is parties raising both misleading and deceptive conduct and unconscionable conduct arguments. The interesting thing about misleading deceptive conduct is you don't necessarily have to have meant to have done it. The fact that it occurred is enough. Okay. Now, really important to understand that this applies both ways. It's not only something available to tenants to raise. Landlords can also raise that a tenant has acted in a misleading or deceptive way, and that could be around supply of information. It could be around the credentials or the references or whatever else that may have been provided to support their application for the lease. It could also be in the context of, say, COVID, if you're giving information across seeking help from the landlord and that information is inaccurate, that again can give rise to these sorts of allegations or claims. Unconscionable conduct, on the other hand, does require a degree of intent. It's not unconscionable for a party to enforce its legal rights. So most of my work at the moment is acting for landlords, and we see it all the time where tenants are saying to a landlord, you're acting unconscionably, when a landlord's just simply acting in accordance with their legal rights. That is not unconscionable. Okay. Unconscionability arises where there's an imbalance of power. Whoever has the balance of power takes advantage of the other person, and they act in a way that completely destroys the relationship. Okay, it's really important to understand if you are raising unconscionable conduct, you need to meet all of those tests, and it is a relatively high bar to achieve. Okay, there are within the fair trading laws at the state and federal level, and also within the Retail Shop Leases Act, some things that a court can have regard to in regards to what might constitute unconscionable conduct. Again, that list is not exhaustive. It can be broader than what is listed in the relevant provisions, but as I said, it is a relatively high bar to achieve, and it's not enough to say that the landlord is just being nasty or the tenant, being silly. You need to show that imbalance of power, advantage taken, and that there's a destruction of the relationship. Default and insolvency, unfortunately, I think is going to become very topical in a couple of months' time. I raise it for a couple of reasons. If you are a tenant and you know you're going to fall into default, start talking to your landlord now. don't put your head in the sand. The worst thing you can do is ignore it and think it'll go away, or ignore it and think that nothing will happen, because that will get you nowhere. Having those open discussions, being honest about what's going on and trying to work together, both landlords and tenants, is the only real way that the issue will be resolved. And if you start those discussions early, then it may mean that there's a much earlier resolution than when things really fall apart. Both parties become upset with each other, so the chances of a negotiated outcome fall away, and all of a sudden the landlord may feel like they're behind the 8 ball, and their exposure and their loss becomes much more significant, so they're much more likely to want to engage. So if as a tenant you feel like you're starting to get into a bit of trouble, start talking to your landlord early. A lot of the tenants may be tempted, if things don't work out, to put themselves into some sort of administration process. So whether that's administration, or they might seek to voluntarily wind up, or they may be being chased by the creditors who are trying to push them into that sort of process. What I'd say is voluntarily going into one of those processes is not always the smartest move. It can trigger all sorts of issues with your finances if you've got them. You may find yourself all of a sudden in default under your financial arrangements. Your financier may then take control, and you've lost control of everything. It also can leave a black mark against your name if it goes all the way through the process to liquidation or bankruptcy. So again, the voluntary administration process is not always the best. There were some reforms announced at the end of last year for small, or I'll say small businesses, but really it's businesses with debts up to $1 million, which is a pseudo type voluntary administration process where a restructuring plan is contemplated. That may be a way to go, but again, looking at that framework and how it's intended to operate, it's not enough to just say I can't pay. You do need to meet some fairly high thresholds. So again, not something to be entered into lightly, but you might think about it. I briefly want to touch on termination issues. Terminating a lease is not always the best outcome for the parties, for a number of different reasons. So as a tenant, again, don't stick your head in the sand and just wait for your landlord to terminate, because they may not do it. A landlord may not elect to terminate. They may elect to go down a different track, which could result in their claim against the tenant being much higher. And likewise for landlords, there are a raft of issues around what they can claim depending on whether they terminate or don't terminate. So termination of lease is always something that needs to be carefully considered, and there is a process that needs to be followed with notices having to be issued and whatnot. The rights in contract ties into that. PPSA, so beware of secured parties' interests. So as a tenant, you may think that allowing the lease to be terminated, you can take all your gear and walk out. If you've given your financier or your franchisor or someone else a secured interest over your fit out, you may not be able to take it. It may not be yours to take. There could be all sorts of issues. Likewise for a landlord, if you think that you can terminate a lease, walk in and take the tenant's property, it's not going to happen. There will be issues around secured parties and whatnot that you may have to deal with. So just be conscious again of that process. And I briefly want to mention unfair terms. The unfair terms or contract regime has been around for a while now. There is no point either party trying to seek terms in their contract that could be considered unfair under that regime. Get on with life. There is no point having extended or a negotiation of leases where all that does is degrade the relationship. A lease is meant to be the start of the relationship, so the quicker that you can form the relationship, the happier basis on which you can start the relationship, the more likely it is that the relationship will succeed. We've seen it over and over again where parties have had acrimonious or extended negotiation of leases. It invariably leads to issues during the term as well, because it sort of sets the tone for the relationship. So just beware of how you're approaching those negotiations. All right, the stuff that most of you probably wanted to hear about today in terms of COVID-19 and the impact it's had on the leasing relationship. I'll go back to March, where we started to see COVID really take hold here in Australia. And what we started to see were the lockdowns and the talk of extended lockdowns particularly. And we saw landlords and tenants start to scramble to see what they could or couldn't do. And each party was trying to guess what the other one was going to do. What we fairly quickly saw was tenants start to look at the doctrines of frustration and force majeure. Frustration is a legal concept where if there is an intervening event in a contractual relationship which makes performance of that contract impossible, then the law will intervene to say that that contract's done and dusted. Okay. COVID-19 has not been seen to be one of those sorts of events. As much as it may have resulted in periods where you couldn't trade or whatever else, the fact of the matter is it has not frustrated leases in the way that some parties have tried to allege. The other thing that was fairly quickly raised was the concept of force majeure. Force majeure is a contractual concept. It must be provided for in the document itself. It's not something that applies broadly. And force majeure is basically something that says that if an event occurs that is beyond the control of a party, then that party is not obliged to perform whilst ever that event is intervening. Now, as I said, that must be provided for in the document. So the lease must say, you know, the tenant doesn't have to pay if there's something that intervenes. No lease has ever said that and probably will never say that. So just, you know, landlords and tenants need to be sensible about force majeure type provisions. It may be appropriate in some circumstances, but broadly speaking, it's not something that you would ordinarily see in a lease. Coupled with those two issues came pleas for rent relief. Some of them were legally based, some of them were just pure and simple, I can't pay, so you need to give me rent relief. And a lot of landlords were resisting that early on for obvious reasons. And I think that's what sort of then led to what we saw happen on the 7th of April, which was the release of a mandatory code of conduct by the National Cabinet. We are the only jurisdiction in the world that has mandated rent relief to be provided by landlords to tenants. So you can understand in that context that landlords initially were potentially a bit resistant to this this process. But what we've seen sort of evolve is a degree of comfort being felt by landlords from the fact that this was sort of dealt with in a legalistic type way, because it gave them some parameters within which to work. It also created the same parameters for tenants, so that tenants didn't have potentially unrealistic expectations of what help the landlord would provide. Now, the national code that we saw released on the 7th of April initially started as something that was retail focused, but over the period of a week or so, from when National Cabinet first saw the proposed retail code, it then turned into a general leasing code. So if you actually read the code, there are some references to retail type issues, despite the fact that it's meant to apply generally. And I think the thing that everyone that's trying to deal with these issues needs to understand is the actual code is not a law, and it's not drafted as law. It's not drafted in a legalistic way. It's very much a document that's meant to help the parties understand the relationship and deal with it at a relationship level. So anyone that's reading the code and trying to interpret it and apply a really legalistic view of it is going to run into trouble, because it's not drafted in that context. The other thing I should say as well is different states brought in their own legislation at different times to try and give effect to what they understood this code to mean. The early adopters of, or the early passers of legislation around the country essentially set up a framework for negotiation. And what they said was that parties have to have regard to this national code in terms of those negotiations. As time went on, and we took until April to pass legislation, and I think that was sort of, in some cases, 2 months longer than other jurisdictions. Sorry, I got my timing wrong of when the national one was released, but ours came out in April. It took that long, I think, because to some extent Queensland Parliament was waiting to see what happened around the country. And if you read our code or our legislation compared to others around the country, ours is a bit of a mishmash of what potentially was perceived to be the best of each of the different regulations around the country. In terms of the Queensland regulation, somewhat similarly to the national code, it is intended to provide the maximum amount of flexibility. So it is not as prescriptive as what some people would think it to be. Ultimately, if anyone asks me what does the Queensland regulation actually require, what it actually requires is the parties to act in good faith and reasonably to negotiate an agreed outcome. It then goes into what the process may look like, and what the parties may have to have regard to, but it's not as black and white as what people seem to be interpreting it. So it really is up to the parties to sit down in a very sensible way, exchange information in a very open and transparent way, and agree a way forward. Okay, so what does that mean in terms of the process? Well, what it means is this: if you seek to try and initiate the process and throw the kitchen sink at it, you're not going to get very far. The reason being, it means the other party has to sit there and think about everything you're throwing at them and potentially respond to everything you're throwing at them and be distracted potentially from the real issues. They may think that issues A, 1, 2, and 3 are the big ones, or in your mind, issues 4, 5, and 6 are the big ones. But because you're throwing all 6 at them, they're going to be distracted and they're going to not see what you're trying to tell them. Okay, because ultimately in a dispute or a negotiation type environment, you will hear something, but what you think that means are two very different things. So we talk about positions and conflict in a negotiation context. You may adopt a position, but the actual conflict is entirely different, and the other party can't see the connection between the two. So it's really important, narrow the issues as best you can, put them forward in as fulsome a way as you can, and back it up. Okay, there is nothing worse, and again, as a landlord lawyer, we see it quite often where tenants they may well have a legitimate claim, but we have no idea what it's worth because they're giving us receipts in a shoebox, or worse, a bank statement saying the deposits on my takings. If you have a claim and it is financially based, you need to have your financial documentation in order. The process that's provided for in the regulation and that Marie's administering doesn't necessarily mean you need to go out and get thousands of dollars worth of reports from your accountants, but you need to have your ship in order, and you need to be able to demonstrate what the financial impact is, and not just say take my word for it. Because again, from a landlord perspective, the bigger landlords are really huge superannuation funds or other investment funds. They're playing with other people's money. The deep pockets that tenants assume they have are not actually their own. They're the pockets of other people. So they need to protect those pockets and not be seen to be just giving money away willy-nilly. So if they're asking you to provide more information, it may be because they agree with you, but they just need to be able to justify it to their fund managers. Okay, so it's not always about slowing down the process. It's not always about being difficult. Quite often it's about substantiating the position. So make sure you can back yourself up. For landlords that perhaps aren't that way set up, it may be high net worth individuals or someone who has a singular investment property. Again, they may not be in a financial position to give all of the help that you need, and they may need to go get help from somewhere else themselves, or they may need you to meet them halfway down the road. The only way that happens is open and honest and transparent communication and exchanging of information. So I can't reiterate that enough. Don't expect to get anything if you're not willing to give anything from an information perspective. I'll make one other point in terms of the process. I was told very early on in my career that a good negotiation or a good mediation is normally one where both parties walk away unhappy. Because what that means is the process has worked. If someone is happy with the outcome, it probably means they got everything they wanted, and the other party is going to be desperately unhappy because they probably lost everything they wanted. So really important that there is that meeting down the road at the appropriate point. Look, in terms of ongoing impact of COVID-19 and what we're seeing, I've just thrown up a random smattering of headlines there from the Fin Review and the Courier Mail. It's been interesting to watch the narrative. So early on, it was all about how rents were going to go down, how there was going to be a huge amount of space available, particularly in the commercial environment, how retail was dead, and how basically everything was going to fall in a heap and there's going to be some great bargains around. That has somewhat dissipated, and certainly early this year we're seeing a lot more positivity. The investors are returning to the market. They're chasing commercial property where there are tenants who traded well during COVID. Early on, we saw the work from home side of things take off and everyone loving it. It seems to be falling away a little bit, and there seems to be a push now for people to return to the office. And it may not be 5 days a week, but certainly to be in the office at least every week for a period of time. So we're not seeing it all fall in a heap the way that we expected it would. So we're not seeing that huge amount of pressure on rent. From a retail perspective, we've actually seen a lot of retailers do very well, other than in the food sector. And those tenants, again, early on, seem to be pushing this barrel of I'll pay you a percentage of my sales. When you're doing really well, that doesn't always work. So we're seeing that come off a little bit, but there will definitely be ongoing issues around how should rents be structured, particularly in a retail context, so that a tenant isn't obliged to pay a rent where potentially they can't because the asset's not able to be accessed or whatever it may be. Online sales have gone through the roof. Australia Post have had record months. They said over Christmas that it was the best they've ever seen, as are other sort of logistics companies. So we're seeing a real flight towards industrial property at the moment, where people are trying to set themselves up for that supply chain. So it's not all bad news. Where we are seeing a huge divergence, though, is in regards to CBD retail, particularly retail that supports the office type worker. We had a recent 3-day lockdown here in Brisbane, and we heard small retail businesses in the Brisbane CBD screaming about the fact that that was really going to impact them. Interestingly, and it's the headline directly underneath the COVID-19 heading there. They were particularly worried about what that meant, and then there was this immediate call for landlords to provide more rent relief. That's a really hard situation because the landlords haven't caused this issue. They're as much affected as what tenants are. We have the mandating of rent relief through to 31 December under the COVID regulation. Tenants can't expect that landlords will continue to fund this. It's just not feasible. It's not sustainable. And what we will see, much in the same way that tenants, if they don't have income, can't reinvest into their business and do the things potentially we need to do. If landlords aren't getting rent, they can't maintain their property, they can't improve it, they can't do those things that tenants perhaps want them to do. And certainly they can't keep the lights on if they're getting zero income, and they can't operate the asset. Particularly say CBD type buildings, they take a lot to get up and running. So for an owner to switch off a building, to turn it back on takes a huge amount of money and a huge amount of investment. So no landlord will want to switch off the building because it's too hard to turn it back on. So we're going to start to see these issues, I think, come out more and more, and we're going to start to see some real arguments about, what should tenants be paying if they're not trading, just so the lights can be kept on and the buildings can be kept running, so that there's not that huge issue potentially of trying to reboot buildings at a later point in time. Have we had any questions come through? So what other options for the tenant who's facing insolvency? I presume you mean other than going through that administration type process. If you're facing insolvency, your options are somewhat limited, because if you trade while you're insolvent and you're the director of the company or you're the individual involved, you may find yourself personally liable. So you don't want to get into a situation where you are trading whilst insolvent. Your options are try and sell the business if you can, and get the landlord to agree an assignment of the lease with whoever the buyer is. Your other options are to try and go get funding from somewhere if you can get it. Other than that, your administration process, there is one other option. Just negotiate with your creditors and try and get an outcome where you're paying them cents in the dollar, or they're forgiving you some debt. They may want you to sign up for, say a landlord might want you to sign up for a longer tenure so that they get a return over a period of time. Other than those three things, there's not a hell of a lot you can do. And the reality is, we were predicting a wave of insolvency March of last year through government intervention as a result of COVID. A lot of businesses have survived the last 12 months, but we are predicting that those that were going to fall over last March will probably fall over this March once government assistance falls away. So sometimes, if something is going to die, it's going to die, and it can't necessarily always be resuscitated or brought out of that spiral. Ultimately, act early. Don't put your head in the sand. Speak to the parties involved. Try and work something out. If you can't, then it'll be what it'll be. But you need to, if you're a company director and you're facing insolvency, you need to think about yourself personally, not just the business, because you could be exposing yourself to personal liability. No more questions? Maria, I had to put you on the spot. Was there anything you wanted to add?
One of the things we get a lot from tenants is what should I be paying now for my rent going forward? What's the value of the lease going forward? What advice would you be giving to those guys?
Yeah, look, that's always a difficult question. As I said, the regulation doesn't really deal with that in a very formulaic or specific way. Really, it comes down to what the parties negotiate, and if the parties can't agree a number, then there are valuers and other people out there that might be able to make that assessment. But with everything that's happening at the moment, you can sort of see from that last slide with the number of headlines that are coming through, particularly at the moment, no one, I think, has a really good feel of what's happening just yet. And as I said, some retailers and other professional services people are trading and through the roof. They're doing especially well at the moment, whereas others are completely died off and are really struggling. So long story short, I think at the moment, a tenant needs to look at their own business and what they can justify as being payable. And, there is a bunch of benchmark data, whether it be from the ATO, whether it be from organisations like Urbis and other who collect this type of information, where they will set a benchmark, and usually it's a percentage of turnover. So they may say for a food business in a premises of this size in this type of location, then the rent that we would expect to be paid is, for example, if the tenant can sit in that sweet spot, then that's all justifiable. There's objective data there to back it up. But if a tenant is saying I only want to pay 4%, the objective data is saying 8 to 10, then the tenant probably needs to think about what the position they're taking and whether that's reasonable or not.
So the key piece of advice there for the small business tenant is what can you afford? What's going to help your business be viable going forward? Because the business model may have shifted due to the way that they now engage with customers. It could be they've now migrated to a digital only, or they might be doing a hybrid model, and the core viability is different. So I think that's something we're certainly seeing through the disputes we've managed as well, is that fundamental understanding the cash flow levers in your business, what's changed, what's within your control, and what's viable for your own business and your circumstance. I think that's really good advice. Yeah,
the only caveat to put on that is what you can afford and what is reasonable may be two different things. So business may not have been performing well before COVID, and this is the nail in the coffin. Right. In that scenario, the landlord should not be copying that. They shouldn't be accepting a rent that isn't commercial. So we've seen it again quite a bit where the concept may have been slightly wrong in the first place. And tenants aren't rejigging the concept, or they're not able to rejig the concept to make it work. In that scenario, maybe the solution
might be a different premises is more suitable at a more affordable rate. So the affordability doesn't necessarily mean stay where you are and just hammer your landlord over the head with a new price. It might be, hey, look at some alternative scenarios and see now how if you don't need a shop front anymore, maybe you need to, so it's all part of the general thing. One of the other questions we see from the tenants that are coming through to us is also about that, how do we get out of a lease? How stuck are we in this situation? Particularly, I'll call out the example of travel agents, where the disruption by COVID is going to have a longer tail, and their need to have a shop front for customers to come is diminishing. So what sort of tips would you give to guys like that about how to get out?
Look, I think, again, get in front of it early, be open about it. Most landlords, in my experience, say using the travel agents as an example, have been really sensible about it. There have been occasions where the tenant has paid a little bit to get out of the lease, and we quite often see surrender fees, depending on how long is left on the lease. But where you might have a few years left on the lease, surrender fee of somewhere between 6 and 12 months worth of rent to give the landlord a little bit of money to try and find another tenant, whatever it is. That's one option. So you pay your way out of the lease. If the lease is ending fairly soon, the landlord probably will accept less. But try and come up with a number that works for everyone. So that's option one. Option two is what we commonly refer to as an undated deed of surrender. And what that is the tenant agrees that they will surrender their lease if the landlord can find a replacement. There's no date put on anything. There may be an ultimate drop dead date, but it gives the landlord the opportunity to go out and market the premises while still having the tenant in place. And that may be on full rent, partial rent, whatever it is. And if the landlord can find someone, then they can say to the tenant, you can go now. It's all up for negotiation. What what can be problematic is where you just walk out the door.
Yeah.
Okay, that's never ever the best solution as far as I'm concerned. In a very small number of cases, the tenant may be best served to do that, but usually there's bank guarantees at play, there's personal guarantees at play, there's fit outs, there's all sorts of things. If you walk out the door, you're potentially blowing the light. It's not going to result in a good outcome.
I think that communication is key. You likened the relationship of a lease to a marriage. Like every relationship in life, communication is always your saving grace. And I think that's also really sound advice, and it's certainly been a common trend that we've seen across all of the disputes that have come through since we've been administering this regulation, is that communication and that financial transparency and sort of what are the. There also seems to be a lot of misunderstandings by one party about the financial circumstances of the other, and that's been feedback from our mediators is don't make assumptions, just come and be willing to be open and have that and see the perspective of the other party in resolving those matters. Is there any other questions that come to your mind, Luke?
No, just reasonableness on both the parties' sides. So what we're finding is a lot of the time the ones that don't settle at mediation are where one party just wants to win. They misunderstand the whole point of mediation negotiation is to not necessarily win at all, but it's to compromise. And a lot of parties just say, well, I'm hard done by, and we see it on both sides, from the landlords and the tenants. Tenants who say, well, my business has been shut down, you've got to give me proportionate rent relief. And then, well, hang on, the landlord might be a small business themselves, they might be a self-funded retiree. We had an example of one person like that where the tenant said, I'm not paying you anything, and the landlord, that was his only income at all, no pension, no nothing, retired chap. But it's about being reasonable and saying, well, I can't pay you now, but I can do something else.
I think one of the key points you made was both the code, which isn't a law and it absolutely is the case, and the regulation. It's a framework for a negotiation to guide the parties towards an outcome. Language like, but I'm entitled to, has been problematic by either party to the commercial lease negotiation. So I think that's a really important factor for landlords and tenants. And we've seen a shift from, initially it was a lot of tenants coming to us with disputes, sort of wanting to understand the rules, what are we entitled to, inverted commas, and it's now starting to see towards the tail end of this, landlords are coming to us and wanting to prompt communication with their tenant. And so that's been part of an interesting journey that we've been observing as well, is the frustrations increasing now on the landlord side, because as you say, they're business people, or they might be small business people, and this is a responsibility they're having to carry, unlike any other jurisdiction in the world. That's really interesting.
Probably a few things to pick up there. The first one is people need to understand this process and mediation is not about the mediator saying to one party you're right, another party you're wrong. They will never ever say that. They'll just want to get the party to talk. Okay, so anyone who thinks that they can use this process to scare the other party or cause them issues or force them to come to the table in a scenario where the party starting it thinks the other party is going to be at disadvantage, doesn't happen. Okay. So that, don't abuse the process. I know your department is very busy at the moment dealing with a number of matters, and I'm sure some of you look at them and go, this is just a trial. This is an abuse of the process. Don't do it, because it's unfair to deprive people who need the help from the help by abusing the process. And secondly, it's not going to get you the outcome that you think you're going to get out of it. The other thing I'd say too is if you're taking on a large corporate and you engage them in a legal process, they will respond legally. And quite often their hands become somewhat tied in what they can do. So think very carefully. You're going to take on a big corporate. I'm not saying this to scare anyone away from the process, but be prepared that you may be having very commercial discussions with that corporate. You then engage them in this legal process and the discussion becomes very legal, which may be contrary to where you want to get to. So be aware about how people's attitudes may change. It's like the marriage. You may be having very cordial discussions about a divorce, then you engage a lawyer and the discussions may well become very different. So just bear that in mind. This process, in my mind at least, is to help parties get past the point where they're stuck, not to try and scare someone to come to a position that you think you're entitled to. Finally, and it goes back to the point I made earlier, don't turn up to mediation unprepared. It's not fair on everyone involved. It's not fair on the department. It's not fair on the mediator. If you are coming in and you just want to say things so you want to say them, you're not going to get anywhere. If you can come in prepared, have the financial statements you may need, have the other material you may need, like objective data supporting your position, that will lead to a much more meaningful and fruitful discussion than just coming in by yourself with nothing and just saying, I want, because I want. It doesn't work. You need to be persuasive in what you're saying. I think we've got another question up there.
Yes.
So the question is, what other examples of offers or negotiations that you can suggest to take to the table to mitigate losses for both parties? Look, everything's a balancing act, and you really can't talk about offers or how you may resolve something without understanding the other party's position. So from a landlord's perspective, like the superannuant that Luke spoke about, income was key for them. They needed the income. Whereas for some others, income may not be the ultimate outcome. It may be maintaining value. And the way that you maintain value if there's a decrease in income is to have longer terms. We refer to a WALE, a weighted average lease expiry. That the WALE and the income are the two real things that impact on valuation. So if they're losing income, they want the WALE to improve so that overall the valuation remains where it needs to be. From a landlord's perspective, they're the two key issues: income, value. So if you can somehow help in your suggestions or offers with either of those two things, understanding which of them is more important to the landlord, then that will get you somewhere closer to getting over the line. From a tenant's perspective, the tenant wants to be able to operate, wants to be able to make a profit, have premises that and an environment that promotes their business. And so sometimes the outcome isn't always a reduction of rent or a necessarily strictly financial outcome. We've quite often had landlords provide marketing assistance to tenants, or provided some sort of infrastructure within the asset, whether it's a capability for delivery or collection of goods or whatever it may be, so that the tenant's business either improves or can be operated in a way that allows them to improve their turnover. Again, it comes down to what the tenant wants to do. If a tenant comes in with a mindset of, I don't want to be there anymore, I just want to walk away, I've had enough, the landlord can get stuffed, they're not going to get much out of the landlord. If they come in showing that we want to be there, we want to do well, we're willing to do all the things that we can do, but we need your help, and again, financial or otherwise, landlords need to be willing to think outside the square a little bit and understand that it may not just be the financial help that's needed, it may be the other type of help to help the tenant's business improve rather than reduce the cost base. Again, that's very much case by case specific, and the only way you get to those issues is by having the frank and open discussion about what's important. So we've come back to it so many times, Marie said it as well, you've got to have that communication in place. One other question, can a previous landlord claim money owed from a COVID rent deferral agreement after they've sold the property? Yes, is a simple answer. The money that they're owed up until the point of sale is still money for them to chase, so they are entitled to pursue that. Obviously, though, they can't take action under your lease. It's just an action for the monies owed. Likewise, the new landlord, unless they have worked something out where they bought the debt, the new landlord can't take action under the lease for breaches when the old landlord was the owner. So, the issue with potentially still owing money to the old landlord and then chasing you for it is they can, take action to try and wind you up, which ultimately isn't going to be a great outcome. I think that's it for the questions. Any other comments, Marie, Luke? Okay. I think that's it for today's session, Miriam.
Okay, well, thank you very much, John. That was excellent session, and thank you to everybody online. I think we've had some great questions and some really good advice today. Probably the big takeaway out of all of that is be proactive. Make sure that if you've got issues and you've got challenges, that you are having those conversations early. and that you are calling first and not getting into sort of an email war or a legal war in terms of your communication. And probably one of the things I heard, and even through the questions, everybody's in it together. There's landlords have their concerns and issues, and tenants have their concerns and issues. So to really get to the table with a mutual obligation together to win and to get a better outcome together would be fantastic. So thank you, everyone. If there is further questions, please do come on the website. You can come through our info@Brisbane link, and we can answer any questions. We also have mentors available through our website. So please, if there's any specific questions, and I'm sure, John, we can have further session of conversations if needed. So greatly appreciated. Not much more to say, only a huge thank you to you for your time today.
Pleasure.
Thank you, Marie, and thank you, Luke. Really topical and important conversation, and thanks to everyone online. Talk soon.
Thank you.